You're watching the legal breakdown. So, Glenn, we've got a new emergency motion that's been filed in the Manhattan District Attorney's case against Donald Trump. Can you speak on that?
Yeah, so I think the prosecutors in Alvin Bragg's case that he's brought against Donald Trump are rightly concerned about how Donald Trump might misuse any evidence or information that the prosecutors deliver to him through his defense attorneys that he's entitled to have as part of what's called discovery in the case. What we do is the prosecutors package up all of the relevant evidence and information. That will be documents and photographs and perhaps statements that were given by witnesses that the prosecutors intend to call at trial. Deliver it all to the defense because they have a right to know the evidence against them. They have a right to know what they're going to need to defend against. And Brian, 99 times out of 100, prosecutors don't have a problem or a concern giving it all over to the defense attorneys because we know it's not going to be misused. We know the defendant's not going to run out and try to tamper with or intimidate or threaten the witnesses, but enter Donald Trump. The prosecutors filed an emergency motion for what's called a protective order. They're saying, look, Judge, we're prepared to give all of this information over to Donald Trump's defense teams, but given Donald Trump's demonstrated history of harassing and threatening, and they actually spell it out. They say, judges, prosecutors, family members, witnesses, grand jurors, regular jurors, and others, that's a quote from the motion.
Yeah.
We want the judge to issue some protective orders that put very strict, tight guardrails around Donald Trump so he cannot put others in harm's way by putting their information, their names out there, and inspiring his supporters to potentially start threatening the witnesses against him. It's an extraordinary ask by the prosecutors when the defendant in the case is a former president of the United States.
Now, how usual is this kind of a request for a protective order?
It's usual in violent crime cases. It's usual in mafia, organized crime cases when we know the person.
He's in pretty good company here.
Yeah, he kind of almost fits both of those definitions, doesn't he?
Yeah.
It's usual in those cases. Why? Because the people we are prosecuting have a known proclivity for violence. That's when we feel like we have to ask a court to put some guardrails up around the information that we're preparing to give over to the defense team. Is it usual in white collar cases? No. I will say that over the years, we prosecutors have been asking for protective orders a little bit more routinely, but I will tell you that was born really of not wanting to compromise witnesses' personal identifying information. For example, when I started prosecuting in the 80s, we were kind of less concerned about redacting out or withholding from the defense, dates of birth and social security numbers. And when we became a little bit more aware with the rise of the internet, how, giving that information over can potentially compromise a witness's safety or security, even if only their financial safety and security, we started to ask for some protective orders a little bit more routinely, but really most specifically, they're used when we think there is a threat to the witnesses involved in the case. That is the circumstance here that has prompted the New York District Attorney's prosecutors to ask for this emergency protective order.
Yeah, leave it to the leader of the law and order party to be a known threat to any of these, witnesses. Glenn, what happens if, and I would argue, and when Trump disregards these new guardrails that have been put in place and does opt to, issue a threat that he's so used to issuing?
Yeah, so that's a great question because once the judge orders that there be these guardrails erected, right, issues a protective order saying Donald Trump may not do X, Y, and Z. And I think we both know Donald Trump will do X, Y, Z, and any other letter he, damn well pleases. Yeah. Then the judge can haul him in and order him to show cause why he shouldn't be held in contempt. The ultimate end game of a defendant who refuses to abide by a judge's limiting or restricting orders is he can be stepped back. He can be imprisoned pending trial. It wouldn't shock me with all of these prosecutions that we believe are in the offing if Donald Trump didn't find himself at the risk of sitting in a jail cell pending trial because he is unable and unwilling to abide by a court's prohibitive restrictive orders.
Is this an instance where Trump's posts, for example, have basically become an unforced error on his part?
Unforced error is a good way to put it. I mean,
A generous term, a gentle term.
there is really nothing stopping Donald Trump from engaging in the kind of lawless, dangerous behavior that he got away with throughout his presidency and his post-presidency. And, at some point, Brian, I think we need to recognize that, Donald Trump is not the problem. We know what to expect from Donald Trump. The problem is the institutions of government that thus far have been unwilling to wrestle that problem to the ground. And that is something that, I scratch my head every day over what has taken, for example, the Department of Justice so long to begin indicting Donald Trump for just some of the crimes we all know he's committed. We've seen the evidence of it in the harsh light of day, and he has admitted to it in interviews he's given or posts on his third-rate social media platform. So, I wish the federal government would step it up and would begin to wrestle that problem to the ground.
Yeah, I think that was perfectly put. I mean, we've spoken at length before about exactly that, about the fact that, when you have people who are committing crimes, when it is your job to hold someone accountable and you fail to do it, at some point, it's not just the person who broke the law's fault when they feel emboldened and empowered to keep committing these crimes if nothing's happening, if the law isn't being upheld. I mean, it kind of makes sense. Glenn, where are we more broadly on this Manhattan DA's case? I know that the next hearing is set for early December, but have there been any new developments otherwise?
Yeah, it seems like it's going to be a very long run up to trial. Part of that is a result of New York allowing for a very robust motions practice. Lots of stuff gets litigated before the case ever proceeds to trial, more so than in other jurisdictions. But right now we have a December status hearing date set. Prosecutors have been clamoring for the earliest possible trial date as early as January, right after that December status hearing. Not surprisingly, the defense team has been saying, no, we need to push it well off into the spring or maybe the summer. Rule of thumb, Brian, prosecutors always want to go to trial yesterday. Defense attorneys always want to go to trial tomorrow, and the judge has to set the trial date. But the defense always wants to delay. Why? Because memories fade, witnesses become reluctant to testify, evidence sometimes goes missing, either, nefariously or innocently. So delay is usually the defendant's friend. So I think we can expect Trump and his legal team to pull out every trick in the book to try to push his trial date as far into the future as possible.
Got it. And will this case, and I know we've spoken about this before, but I think it's worth repeating, will this case have any bearing on his ability to run for office in the future?
No legal bearing, maybe political bearing, but he's charged with 34 felony false business records crimes. That will not, even if he's convicted on all 34 counts, it will not impact his legal ability to run for office. Now, it should result in some jail time. So how a presidential candidate can effectively run from a jail cell, that's an open question. It's an issue we haven't had to contend with in our nation's history, but I can only imagine it will probably inspire, the hardcore members of his base to part with more of their money. He will continue the grift until his dying day. I can't imagine it's going to help him, though, politically.
Glenn, in similar cases, and I shouldn't say in similar cases because obviously this is unprecedented, but when you have high-profile defendants in cases like this, and they obviously are subject to jail time, does that always play out that way? I feel like the more connected somebody is, the less likely it is that they'll actually end up rotting in a prison cell somewhere. So how does it usually work when you have a high-profile or super wealthy or super well-connected defendant who is ultimately found guilty on in this case as many as 34 criminal charges?
Brian, nobody can accuse our criminal justice system of keeping its eye on the equal justice ball. If you are poor, you're indigent, you're a person of color, you're a minority, you're more likely to land in jail, all things being equal. But if you are rich, if you are influential, you're connected, you're a member of the ruling class, you're white, you're male, you can often find yourself in a much better situation than your minority counterparts. But, 34 felony convictions, if the jury in New York convicts him on all counts, it will almost certainly result in at least some jail time. It may only be 6 months. May only be a year or two. But, the white collar criminals, what I call the ruling class criminals, are often able to sort of buy their way out of jail time, not by bribing people, but often by, agreeing to pay exorbitant fines and penalties and restitution if the judge, please, will just sentence me to perhaps a suspended sentence and a period of probation. It doesn't seem like our criminal justice system is up to treating everybody equal. And that's a problem that I think we have to work on and we have to fight against every day.
But now in this situation where we have the judge in this case, I believe it's Judge Merchan, is that correct?
It is.
So if we have Judge Merchan, who, I mean, this is such a high profile case, the eyes of the entire country, the entire world are going to be on this trial. Would it make it less likely then that the judge would allow for easier treatment if he promises more money, if he promises to pay restitution? Is it less likely that he would do that because it would just be such a blatant, I mean, it's basically akin to bribery in this case. So would he be less likely to do it given that the eyes of the world are going to be on him in this case, and he'll just go solely, move forward solely just with the idea of justice in mind?
Only Judge Merchan knows for sure. I'll tell you, he seems like a straight up judge, given the way he's been handling the litigation, given the rulings he has been entering. And now remember, Judge Merchan has been threatened. His family members have been threatened, sort of de facto threatened by some of what Donald Trump posted. He also has seen Donald Trump threatening Alvin Bragg and his family members. So it's hard, I think, to believe that Judge Merchan can divorce all of that from his view of what the appropriate sentence would be for Donald Trump. And here's the other thing. This is not just your run-of-the-mill false business records where somebody is perhaps playing games with the books to keep a little bit of money in their own pocket, maybe avoid paying some taxes that they ought to be paying. This is somebody who is engaged in a concerted effort and course of conduct to falsify business records. Why? To steal the 2016 presidency from the American people.
Yeah.
I have a feeling at the end of the day, Judge Merchan will absolutely sentence Donald Trump to a term in prison.
From your lips to God's ears. Obviously, we'll keep on top of this case as soon as we have any new updates. For those watching, if you want to stay on top of legal news, make sure to subscribe. The links are right here on the screen. I'm Brian Tyler Cohen.
And I'm Glenn Kirshner.
You're watching The Legal Breakdown.